of your own clients that have had events that have either been postponed or pushed out. Maybe you could share with us that story so we could learn a little bit as marketers how a lawyer thinks of that world.
Sure, sure. Happy to help. And just to clarify that I am not rendering any legal advice, but I am happy to give illustrative examples and things of what I'm seeing. So there are, as you know, force majeure clauses in almost every contract. The force majeure contracts actually, as you know, will list various qualifying events. And if those events arise, they generally excuse both parties' obligations without further liability. But force majeure clauses are very, very narrowly interpreted. And usually, if a qualifying event, such as in this instance, the coronavirus, the pandemic, isn't really listed, to some extent, it can still be offered up. And I think that there is, the ABA actually came up with something today. And I think in most instances, even if pandemics or epidemics are not listed as qualifying events, we can still use this clause, which is beyond a party's control, that rendered the services either impracticable or impossible on a successful prevailing basis.
Mm-hmm.
So what needs to happen is that I would suggest your colleagues look at force majeure clauses, look to see whether epidemics and or pandemics are listed. And again, given that the WHO actually declared on March 11th, this pandemic, it would be a qualifying event if, again, it's listed, specifically listed. I would also urge you and your clients to look very closely at the notice provisions, because as force majeures are really narrowly interpreted, clients are really going to have to follow by the book whatever prompt notice, prompt written notice is required under that contract. There are other issues that need to be also proved, which is that the event was not foreseeable, which in this instance we can say that it was directly caused, or it directly caused failure to an individual's performance under the actual contract.